maybe you better say maybe. So if you want to say maybe now and be really honest, say maybe. Otherwise, I hope you'll answer that October 17th letter once we get you voted into office.
Yes, Senator.
Throughout your career, you've expressed concern with congressional attempts to enact criminal justice reform and at times advocated for stricter mandatory minimum sentences. In '92, under your direction, DOJ published a report entitled "The Case for More Incarceration." This report declared that the problem with our criminal justice system was that we were incarcerating too few criminals. More recently, in 2015, you signed a letter opposing the Sentencing Reform and Corrections Act of 2015. This letter states quite clearly your opposition to sentencing reform, particularly the lessening of mandatory minimum sentences, any sort of retroactivity. The First Step Act was signed by President Trump. As Attorney General, it'll be your job to implement the legislation. Even though you've opposed criminal justice reform in the past, will you commit to fully implementing the First Step Act?
Yes, Senator. But in 1992, when I was Attorney General, the violent crime rates were the highest in American history. The sentences were extremely short. Typically, in many states, the time served for rape was 3 years. For murder, time served 5 to 7 years. It was, the system had broken down. And I think through a series of administrations, Reagan, Bush, and Clinton, the laws were changed, and we targeted chronic violent offenders, especially those using guns. And I think the reason the crime rate is much lower today is because of those policies. So I don't think comparing the policies that were in effect in 1992 to the situation now is really fair. And I think, and I've said that right now we have greater regularity in sentencing. There's broader recognition that chronic violent offenders should be incarcerated for significant periods of time to get them off the streets. And I think the time was right to take stock and make changes to our penal system based on current experience. So I have no problem with the approach of reforming the sentencing structure. And I will faithfully enforce that law.
Don't take it personal if I raise my voice to you. I'm not mad at you.
If I were you, I'd answer his letters just as sort of a tip that may help you through your job if you get it. I'll take the time away from my second round. I'm very curious about the conversations you had about personal representation being Attorney General. You mentioned it, Senator Feinstein. Can you just kind of give us a summary of what you were talking about?
Yeah, so in June of 2017, middle of June, Ambassador David Friedman, who's the U.S. ambassador to Israel, who I didn't know. I knew that he was a top-tier lawyer in New York and apparently a friend of the president's. He reached out to me and we talked one evening, and he said that my understanding was he was interested in finding lawyers that could augment the defense team, and failing that, he wanted to identify Washington lawyers who had broad experience that whose perspective might be useful to the president's. And he asked me a number of questions like, what have you said about the president publicly? Do you have any conflicts and so forth? And I told him that I didn't think I could take this on, that I had just taken on a big corporate client that was very important to me and I expected a lot of work. And I said at my point in life, I really didn't want to take on this burden, and that I actually preferred the freedom to not have any representation of an individual, but just say what I thought about anything without having to worry about that. And I said that my wife and I were sort of looking forward to a bit of respite, and I didn't want to stick my head into that meat grinder. He asked me if I would nonetheless just briefly go over the next day to meet with the president. And I said, sure, I'll go and meet with the president. And he brought me over, and was squeezing me in. It looked to me like it was before the morning staff meeting because people were grouping by the door to get in, and I went in. And he was there, the ambassador was there, sat through the meeting. It was a very brief meeting where essentially the president wanted to know, he said, oh, you know Bob Mueller. How well do you know Bob Mueller? And I told him how well I knew Bob Mueller and how, the Barrs and Muellers were good friends and would be good friends when this is all over and so forth. And he was interested in that, wanted to know, what I thought about, Mueller's integrity and so forth and so on. And I said, Bob is a straight shooter and should be dealt with as such. And he said something to the effect like, so are you envisioning some role here? And I said, actually, Mr. President, right now I couldn't do it. My personal and my professional obligations are such that I'm unable to do it. So he asked me for my phone number. I gave it to him, and I never heard from him again until.
Well, I tried that once. So you did better.
Well, I didn't hear from him until later, but about something different, which was the Attorney General position.
Oh, thank you, Mr. Barr. Good to see you again. As you mentioned, Senator Grassley and I were here at your hearing a number of years ago. Let me go back even before that. 46 years ago, I was not in the Senate. I was state's attorney in Vermont, and I watched with a great deal of interest the Elliot Richardson hearings. He'd been nominated to be Attorney General as the midst of Watergate. He made several commitments to the committee, including appointing a special prosecutor, and he promised to protect his independence. And as one who had total independence as an elected prosecutor in Vermont, I thought how important it was to have that same independence at the national level. And Mr. Richardson said it was necessary to create the maximum possible degree of public confidence in the integrity of the process. I've never forgotten that. But I think the integrity of our institutions is just as much at risk today. President Trump has made it clear he views the Justice Department as an extension of his political power. He's called on it to target his opponents. He obsesses over the Russia investigation, which looms over his presidency, may define it. He attacks the special counsel almost daily. He fired both the previous FBI director and attorney general for not handling the investigation as he pleased. That tells me the rule of law can no longer be taken for granted. So if confirmed, the president's going to expect you to do his bidding. I can almost guarantee you he'll cross the line at some point. That's why the commitments you make here today, just like those I watched Elliot Richardson make years ago, matter greatly. So will you commit, if confirmed, to both seeking and following the advice of the department's career ethics officials on whether you must recuse from the special counsel's investigation?
I will seek the advice of the career ethics personnel, but under the regulations, I make the decision as the head of the agency as to my own recusal. So I certainly would consult with them, and at the end of the day, I would make a decision in good faith based on the laws and the facts that are evident at that time.
Same thing if you're talking about a conflict of interest?
Well, no, some conflicts, as you know, are mandatory.
I'm thinking what Attorney General Sessions, and when asked a similar question, he said he'll seek and follow the advice. Seek and follow the advice of the Department of Justice's designated ethics officials. So let me ask you, maybe in a different way. I know you promised to not interfere with the special counsel. Are there any circumstances that would cause you to terminate the investigation or any component of it, or significantly restrict its funding?
Under the regulations, Bob Mueller could only be terminated for good cause, and frankly, it's unimaginable to me that Bob would ever do anything that gave rise to good cause. But in theory, if something happened that was good cause, for me, it would actually take more than that. It'd have to be pretty grave, and the public interest would essentially have to compel it, because I believe right now the overarching public interest is to allow him to finish.
I would agree with that, but I also think over the past 18 months, you rather harshly prejudged the investigation in some of your writings.
Well, I don't see that at all, Senator. You know, when you strip away a lot of the rhetoric, the two things that have been thrown up as me sort of being antagonistic to the investigation are two things. One, a very mild comment I made that, gee, I wish the team had been more balanced. I wasn't criticizing Mueller. I believe that prosecutors, and I think you would agree, they can handle the case professionally, whatever their politics are. A good prosecutor can leave their politics at the door and go in and do the job. And I think that's what Justice Department prosecutors do in general.
But you also are very critical of the Russian probe. And I mean, I can't think of anything that would, in your memo, for example, that would jump out more for this president because of his commitment to it. And I ask that because some have said on both sides, that it looked like a job application. And so that's what I want you to refer to.
Well, that's ludicrous. If I wanted the job and was going after the job, there are many more direct ways of me bringing myself to the president's attention than writing an 18-page legal memorandum,
or
sending it to the Department of Justice and routing it to other.
But also publicly criticizing the Russian probe. I mean,
how have I criticized the Russian probe?
You don't have any criticism of the Russian probe?
Not at all. I believe the Russians interfered or attempted to interfere with the election, and I think we have to get to the bottom of it.
So you would be in favor of releasing the investigative report when it's completed?
As I've said, I'm in favor of as much transparency as there can be, consistent with the rules and the law.
Do you see a case where the president could claim executive privilege and say that parts of the report could not be released?
Well, I don't have a clue as to what would be in the report. The report could end up being, not very big. I don't know what's going to be in the report. In theory, if there was executive privilege material to which an executive privilege claim could be made, it might, someone might raise a claim of executive privilege.
That'd be pretty difficult following U.S. versus Nixon when the Supreme Court unanimously rejected President Nixon's claims of executive privilege over the Watergate tapes. But I ask it because the president's attorney, Mr. Giuliani, said the president should be able to correct the Mueller report before any public release. So in other words, he could take this investigative report, put his own spin on it, and correct it before it's released. You commit that would not happen if you were Attorney General?
That will not happen.
Thank you. You had, when you're AG, I remember this well because I was here in the Senate at the time, you encouraged President George H.W. Bush to pardon all 6 individuals who were targeted in Iran-Contra. The independent prosecutor investigating the matter labeled that a cover-up. Now, you and I talked about this in my office, and I appreciate you coming by. I found the conversation the two of us had be well worthwhile. Do you believe a president could lawfully issue a pardon in exchange for the recipient's promise to not incriminate him?
No, that would be a crime.
Thank you. in 1990, you argue that Congress appropriation power is not an independent source of congressional power to control the allocation of government resources. There are only 3 committees in the Senate to have a vice chairman. Appropriations is one of them. Obviously, as vice chairman, I kind of looked at that. You claim that if a president finds no appropriated funds within a given category, he may use funds from another category, as long as both categories are in his constitutional purview. Now, this says Vice Chairman Appropriations Committee. Don't be surprised, I disagree. Congress's power of the purse, Article 1, Section 9, I believe constitutes one of the most fundamental and foundational checks and balances on the executive branch. So do you believe the president can ignore Congress appropriations allocations, conditions, and restrictions in law? Just ignore them and take the money and transfer it?
Not as a general proposition, but I just, that was
a general proposition.
I actually thought that was a good law review article. I gave it as a speech, and it was really a thought piece, and what I was really saying was, and I say right up front, that the more I thought about the appropriations power, the more confused I got, and I was just laying out a potential template, which is this. People frequently say, you know, the power to, you know, spend money on this division or this missile system is part of the power of the purse. And what I was actually saying was, you know, actually what the power being exercised there is the substantive power that Congress has to raise armies. And it's not, it doesn't come from the power of
specific appropriations on agriculture or on defense. I mean, for example, could a president just build a wall along our southern border because he wanted to and just take the money, whether appropriate or not? What about eminent domain?
What about eminent domain?
Well, if you're going to build a wall, you got to take a whole lot of land away from landowners in Texas and elsewhere.
Well, you know, you'd have to show me what statute is being invoked and also what appropriations is being used. I can't answer that in the abstract.
So you're saying the president, though, can have the power to go into money even if the Congress is appropriated for a different purpose?
I didn't say that. But some
You mean that?
I don't mean that. I'm saying that you know, there are monies that the president may have power to shift because of statutory authority.
But that would have been because Congress gave him that authority.
Right.
Not because he has it automatically.
I'm not taking that position. As I said, my law review, it was published as a law review article, and it was a thought piece exploring what limits there might be to the appropriations power and where Congress's power comes from in certain areas.
Thank you. Thank you, Mr. Chairman.
Just to follow up on that real quick, and I won't take this against their corner. To the Article 2 powers, the inherent authority of the Commander-in-Chief, give him the ability to take appropriated dollars for the Department of Defense and build a wall.
I can't, without looking at the statute, I really couldn't answer that.
I'm not talking about a statute, I'm talking about the inherent authority of the President as Commander-in-Chief.
That's the kind of question I would go to OLC to answer.
Okay. Get back with us on that. Senator Corn.
Well, Mr. Chairman, let me congratulate you on your election as chairman of the Judiciary Committee and tell you we look forward to working with you and supporting this committee's efforts. Thank you for convening today's hearing. And I want to express my profound and sincere thanks to the nominee, Mr. Barr, for agreeing to serve a second time as Attorney General. I noted in your statement, you said it was 27 years ago that you sat in this chair and went through your first confirmation hearing. And to me, that says a lot about your character and your commitment to the rule of law, that you would be willing to go through this process again and serve once again as the chief law enforcement officer of the country. Thank you for doing that.
Thank you, Senator.
Thank you to your family as well. To me, the Attorney General is one of the most challenging cabinet offices to hold because, as you point out in your opening statement, you are committed to the rule of law and enforcing the laws of the land, but you are also a political appointee of a president. If you are serving another cabinet position, certainly you're committed to implementing the president's agenda or the agenda of an administration, but as Attorney General, that is not an unequivocal commitment, because there may be some things that the administration wants you to do that you cannot do consistent with the rule of law, correct?
That's right, Senator. One of the reasons I ultimately decided that I would accept this position if it was offered to me was because I feel that I'm in a position to be independent. You know, over the years, a lot of people have, some politicians have called me up saying, you know, I'm thinking of going for the Attorney General position in this administration and so forth. And I say, you're crazy. Because if you view yourself as having a political future down the road, don't take the job. Because if you take this job, you have to be ready, you know, to make decisions and spend all your political capital and have no future. Because you have to have that freedom of action. And I feel I'm in a position in life where I can do the right thing and not really care about the consequences, in the sense that I can truly be independent.
Mr. Barr, thinking back about the run-up to the 2016 election, where the nominee of both political parties for President of the United States ended up being investigated by the FBI, can you think of any precedent in American history where that's occurred that you know of?
No, I can't, Senator.
And thinking back to James Comey's press conference of July the 7th, 2016, where he took the step of talking about the evidence against Mrs. Clinton, talking about the legal standard that would apply as to whether she might or might not be indicted for committing a crime under the Espionage Act. Have you ever seen a situation where an FBI director would usurp the authority of the Department of Justice to make that charging decision and hold a press conference and talk about all of the derogatory information that the investigation had gleaned against a potential defendant, and then say, now we're not going to, no reasonable prosecutor would indict her? Have you ever seen anything like that happen before?
No, I've never seen that, and I thought it was a little bit, more than a little bit. It was weird at the time, but my initial reaction to it was, I think Attorney General Lynch had said something, you know, she was under pressure to recuse herself, I think, because of the so-called tarmac meeting. Right. And I think she said something like she was going to defer to the FBI. Mm-hmm. So my initial reaction to that whole thing was, well, she must have agreed, or it must have been the plan, that he was going to make the decision and go out and announce his decision.
Under the normal rules, if the Attorney General has a conflict of interest,
it would go to the deputy.
It would go to the deputy,
correct,
not to the FBI director to make that decision, correct?
Right, so that's why I thought it was very strange, but I think later it became clearer, to the extent there's anything clear about it, that I don't think Attorney General Lynch had essentially delegated that authority to the director. Now, I think Jim Comey is as I've said, is a extremely gifted man who's served the country with distinction in many roles. But I thought that to the extent he actually announced a decision was wrong. And the other thing is, if you're not going to indict someone, then you don't stand up there and unload negative information about the person. That's not the way the Department of Justice does business.
I was shocked when Mr. Comey later wrote a letter saying that based on the discovery of Clinton emails on the Wiener laptop, that they were reopening the investigation that he had already announced closed. And then finally, just days before the general election, November the 6th, 2016, said, we didn't find anything on the laptop that would change my conclusions based on the press conference of July the 6th. Did you likewise find that to be an extraordinary, I will use the word bizarre, but certainly unprecedented event?
Yeah, the whole sequence was very herky-jerky and bizarre, but at that time, I was a little of a contrarian in that I basically took the position that once he did what he did in July and said the thing was over, and then found out it wasn't over, he had no choice but to correct the record. So I said that he had no choice but to do what he did, but it sort of shows you what happens when you start disregarding the normal procedures and established practice, is that you sort of dig yourself a deeper and deeper hole.
Why is it that the Department of Justice rules, which also apply to the FBI, make it clear that our chief law enforcement agencies in this country should not get tangled up in election politics? Are there policies in place that try to insulate the investigations and the decisions of the Department of Justice and FBI from getting involved in elections?
Yes, Senator, there are.
And why is that?
Well, obviously, because the incumbent party has their hands on the among other reasons, they have their hands on the levers of the law enforcement apparatus of the country, and you don't want it used against the opposing political party.
And that's what happened when the counterintelligence investigation of the Trump campaign began in late July and continued on through, well, presumably to Director Comey's firing and beyond.
Well, I'm not in a position to, make a judgment about it because I don't know what the predicate was for it. I think I said, it's strange to have a counterintelligence investigation of a president, but I'm not, I just don't know what the predicate is, and if I'm confirmed, I assume I'll find out.
Rod Rosenstein's memo recommending the termination of James Comey as FBI director was dated May the 9th, 2017. It's entitled Restoring Public Confidence in the FBI. I take it you've read the memo, and do you agree with its conclusion?
I completely agree with Rod Rosenstein, and I thought the important point he made from my standpoint was not the particular usurpation that occurred, but it was, as I think he says, that Director Comey just didn't recognize that was a mistake, and so it was going to potentially be a continuing problem, that his appreciation of his role vis-a-vis the Attorney General.
As I said, the title of the memo is Restoring Public Confidence in the FBI. Do you agree that restoration of public confidence in the FBI and Department of Justice as a apolitical or non-political law enforcement organization is important?
It's critical
and needed.
It's critical, and that's one of the reasons I'm sitting here. I'd like to help with that process.
Well, Mr. Barr, I think you're uniquely qualified to do that, and I wish you Godspeed.
Thank you, Senator.
It couldn't be more important. Thank you.
Mr. Barr, we've never had a chance to meet, but I welcome you to this committee.
Thank you.
You seem like a rational person. I'd like to ask you a question. When you consider what Jeff Sessions went through as the Attorney General for President Donald Trump, where he was subjected to unrelenting criticism, primarily because, as a matter of conscience, he decided he had a conflict of interest and should remove himself from any decisions by the special counsel concerning the Russia investigation. When you consider that this president has lashed out on a personal basis against federal judges who ruled against his administration, when you consider the criticism which he has leveled at the chief law enforcement investigative agency of the Department of Justice, the FBI, as well as our intelligence agencies, when you see the exit lanes glutted, those leaving the White House at every single level, why do you want this job?
Well, because I love the department. I love and all its components, including the FBI. I think they're critical institutions. that are essential to preserving the rule of law, which is the heartbeat of this country. And I'd like to think that there was bipartisan consensus when I was last in this position, that I acted with independence and professionalism and integrity, and I had very strong and productive relationships across the aisle, which were important, I think, to trying to get some things done. And I feel that I'm in a position in life where I can provide the leadership necessary to protect the independence and the reputation of the department and serve in this administration.
A number of my colleagues on both sides have asked, and I'll bet you'll hear more, questions along the line of what would be your breaking point? When would you pick up and leave? When is your Jim Mattis moment when the president has asked you to do something which you think is inconsistent with your oath? Doesn't that give you some pause as you embark on this journey?
It might give me pause if I was 45 or 50 years old, but it doesn't give me pause right now, because I had a very good life. I have a very good life. I love it. But I also want to help in this circumstance, and I am not going to do anything that I think is wrong, and I will not be bullied into doing anything I think is wrong by anybody, whether it be editorial boards or Congress or the president. I'm going to do what I think is right.
You have a very nice family behind you.
Thank you.
I'm glad you introduced.
Thank you, sir.
And I don't want to give your grandson any career advice. He's received quite a bit this morning already. But he ought to consider, at least for some balance, being a public defender. One of the things that you alluded to as a major issue of concern is immigration. I'm glad you said it. Our government is shut down now over the issues of border security and immigration. And the Attorney General plays a central role, which many people don't know as they look at the Department of Homeland Security for most of the action on the issue of immigration. I was surprised at the exit interview by General Kelly when he said, and I'm paraphrasing, that Attorney General Sessions was responsible for the zero tolerance policy that was announced in mid-2018, and that it was because of that policy, that was one of the reasons why he was being asked to leave. That's the first I'd ever heard. Are you familiar with the zero tolerance policy?
Generally, Senator, yes.
I can tell you that it was an effort to take escorted children, infants, toddlers, and children, and forcibly remove them from their parents at the border. This policy by our government separated up to 2,800 of those children and put them into the system, the same system as unaccompanied children. The results were horrible. I saw them firsthand. And you have alluded in your opening statement to stopping people from crashing through the border, breaking and flouting the laws. Those young children, for the most part, were being brought to this country by their parents to seek asylum. You can present yourself at America's border and seek asylum legally, can you not?
Yes, Senator, you can.
So separating those children from their parents in an effort, as Attorney General Sessions explained, to get tough with families presenting themselves at the border, was a policy decision on his part. Do you agree with that policy decision?
Well, I'm not sure I know all the details, because one of the disadvantages I have is I'm not in the department and don't really have the same backing I did in terms of information that I had last time. But my understanding is that DHS makes the decision as to who they're going to apprehend and hold. Now, you can claim asylum, but that doesn't mean you can waltz into the country
No,
freely.
of course not.
Okay, and you have to be processed. And my understanding is a majority of people do not qualify for asylum. But DHS makes a decision who to hold and charge with the crime of illegal entry. And then they refer it to the Department of Justice. And I believe the department's policy, when the department says zero tolerance, they're saying whatever DHS refers to us in the way of illegal entry prosecutions, we'll prosecute. Now, Now what is being done, because I think the administration has changed the policy, is DHS is not referring for prosecution family units that would lead to the separation of children from the family
It's
unit.
true that the president and the administration abandoned the policy after there was a public reaction to the separation of these children. I'm concerned, I want to go back to your University of Virginia Miller Center speech, which is
It's a gem, isn't it?
it's a classic, and it goes back many years. But you described your previous tenure as Attorney General, and you said, after being appointed, I quickly developed some initiatives on the immigration issue that would create more border patrols, change immigration rules, streamline processing. It would furthermore put the Bush campaign ahead of the Democrats on the immigration issue, which I saw as extremely important in 1992. I felt that a strong policy on immigration was necessary for the president to carry California, a key state in the election. That's a pretty revealing statement about a political agenda.
Yeah, there's nothing wrong with that, because as I've said, you know, the attorney, and I've spoken on this a number of times, there's sort of three roles the Attorney General plays. One is the enforcer of the law, and that the role of the Attorney General is to keep the enforcement process sacrosanct from political influence. The second one is as legal advisor, and that is in the Judiciary Act of 1789, legal advisor to the President and the Cabinet. And there I say the Attorney General's role is to provide, you know, unvarnished, straight from the shoulder legal advice as to what the Attorney General believes is the right answer under the law. And then the third role is the policy role, which is law enforcement policy, which includes immigration policy. And there you are a political subordinate of the president, and it's okay to propose policies that are politically advantageous. But I have to say that, you know, that was casual conversation. The point was, I was pursuing a strong immigration policy even when I was deputy, long before, you know, the election was on the horizon. And in traveling around the country, visiting the border, paying a lot of visits to California, I saw how important the issue was. And I thought the administration had to be more responsive to it. And yes, there was a political benefit to it.
I just have a short time left. The chairman, our new chairman, congratulations, Graham, noted 10 years of work by a number of us on this committee on a bipartisan basis to deal with criminal sentencing and prison reform. And the First Step Act signed by the president around Christmas, I think, is a significant departure. I learned, as many have, that the approach, the get tough approach that we imposed with 100-to-1 sentencing disparity between crack and powder didn't work. Did not work. The number of drugs being sold on the street increased. The price of the drugs went down. The people being incarcerated went up dramatically. And we learned the hard way. That was not the way to deal with the issue. And now we're trying to clean up 10 years later, or more, 25 years later, from the 100-to-1 disparity. I voted the wrong way on 100-to-1. Now I know, in retrospect. You've made some hardline statements about this issue and criminal sentencing in the past. And many of us believe, on a bipartisan basis, we've got to look at this anew and not repeat these mistakes again. So I would like to hear your assurance that you have learned, as I have, that there is a better way, could be a more effective way, and that as Attorney General, you will help us implement the First Step Act and design the second step.
Absolutely, Senator. From my perspective, the very draconian penalties on crack were put into place initially because when the crack epidemic first hit, it was like nuclear weapons going off in the inner city. And as I think you'll recall, a lot of the community leaders at that time were saying, you gotta, you know, this is killing us, you have to do something. So the initial reaction of draconian penalties was actually, you know, trying to help those communities. And over time, and now the same leaders are saying to us, this has been devastating, you know, generation after generation of our people are being incarcerated, have been incarcerated and lost their lives because of this, and you have to change the policies. And I think that is we should listen to the same people we were listening to before. I supported generally strong penalties on drugs because, not just crack, because I felt the money involved was so high that, you needed something to counteract that. I also said repeatedly over the years of the drug war that I felt that the head of the snake is outside the country. And the place to fight this aggressively is at the source more than on the street corner. And I used to say we could, stack up generation after generation of people in prison and it'll still keep on coming. And so I always felt that, and I support a adjustment to these sentences and the safety valve and so forth. To me, the corollary is we have to really start thinking and using all our national forms of power in the sense of our diplomacy and our economic leverage and so forth to get better results overseas. So, for example, now fentanyl is sort of the new crack. Fentanyl and fentanyl analogs are sort of the new crack, and they're coming in from China. So,
Across the Mexican border,
correct.
at ports of entry, 90%.
So that's a long-winded answer to your question, which is I understand that things have changed since 1992. I held on a little bit longer to keeping strong sentences maybe than others. Part of that was I wasn't involved in the business anymore. I wasn't at Justice Department looking at reports and studies, learning about different things in the country. I was, arguing with the FCC about telecommunications rules. So,
Ms. Barr?
yes.
That was a great answer, and it was long-winded.
Okay.
Senator Lee.
Mr. Barr,
After this, we'll break to 12:15 for lunch and a comfort break.
Mr. Barr, thank you very much for your willingness to spend time with us today and your willingness to be considered for this important position yet again.
Thank you.
Great to have your family here. And I can't help but comment, a lot of people have talked about Liam today, probably more than any of his other friends or classmates, people of his age cohort. People were thinking about what he might do for a living. Unlike some of my colleagues who have suggested medicine, I want to just sort of suggest what I've suggested to my 3 children, which is that I'm not going to push them into any career choice, which in our family means that you can be any kind of lawyer you want. Just keep that in mind with Liam. I'd like to talk to you first about civil asset forfeiture. As you know, civil forfeiture and criminal forfeiture are 2 very different things, 2 very different species of government taking someone's asset. With criminal forfeiture, of course, the government's ability to take something away is predicated upon a conviction of a crime. With civil asset forfeiture, that happens even in the absence of a conviction. There are some serious questions, of course, regarding the legality and constitutionality of civil asset forfeiture. And Justice Thomas, for example, has questioned whether some of these practices are constitutional. I was encouraged to note that in your testimony in 1991, you identified this as an issue. When you testified before this committee, you criticized what you described as the speed trap mentality of forfeiture. Your point was that, quote, agencies should not feel that just because they seize money, they're going to get the money, close quote. Now, since 1991, I've seen our government, our law enforcement agencies actually move more toward this sort of speed trap mentality rather than away from it, as many of us would have preferred. Too often, law enforcement agencies have too strong an incentive to use civil asset forfeiture in a way that lines their own coffers outside of the relevant appropriations process. So let me just ask you the question: Do you think that the speed trap mentality is a problem? And if so, is that something that you'll work to address within the Department of Justice if you're confirmed?
Yes, I think constant vigilance is necessary because there are incentives there that should be of concern in administering the law. And I understand that there are some people who are concerned about it, have some horror stories. The people at the Justice Department have been trying to clamp down. I think Attorney General Sessions put out some guidelines that were supposed to address that. I haven't gotten into it myself. I plan to get into it and see exactly, what the horror stories are, where the problems and potential abuses are, and also whether Attorney General Sessions' guidelines are providing sufficient protection. At the same time, I think it is a valuable tool in law enforcement, and the state and local law enforcement officer, our partners, it's very important to them. So I want to make sure we strike the right balance. And once I have a chance to review it, I'd be glad to come up and talk to you about that.
Thank you. I appreciate that. I understand that it's a tool that many consider valuable, but a tool that can be considered valuable for some of those same reasons. Something that's considered valuable to the government can, in many instances, jeopardize an individual right that is protected under the Constitution. We've got to be careful of that. When you refer to the partnership that sometimes takes place between state and federal authorities, this is sometimes where we see it abused. In the case of procedure known as equitable sharing, where sometimes state law might prohibit the use of civil asset forfeiture under certain circumstances. And in those circumstances, those state law enforcement agencies might work with federal law enforcement for the specific purpose of evading state law that would otherwise prohibit that. So I hope that's something you'll look into as well. Yes. Let's talk about antitrust for a minute. Along with Senator Klobuchar, I chair the antitrust subcommittee. And as I'm sure you're aware, there are a growing number of people who take the position, who embrace the viewpoint that we should use antitrust law to address a whole host of social and economic harms, to, among other things, to ensure that companies respect the First Amendment, or to prevent large companies from becoming too big, or to shape labor markets, or to conform industries to a particular aesthetic, or achieve some other broadly defined social interest. I'd like to know what your view is on this. Are you a believer in the sort of big is bad mentality, or do you gravitate more toward the idea that our antitrust laws are there to protect consumers and should focus on consumer welfare and prices that consumers face?
Yes, I mean, generally that's where I stand, which is the purpose of the antitrust laws, obviously, is to protect competition, and that it is competition that ultimately redounds to consumer benefits. At the same time, I'm sort of interested in stepping back and reassessing or learning more about how the antitrust division has been functioning and what their priorities are. I don't think big is necessarily bad, but I think a lot of people wonder how such huge behemoths that now exist in Silicon Valley have taken shape under the nose of the antitrust enforcers. And you can win that place in the marketplace without violating the antitrust laws. But I want to find out more about that dynamic.
Right. Yeah, and in some circumstances, a company that becomes too big ends up behaving in a way and exerting market dominance in a way that impairs consumer welfare anti-competitively. In other circumstances, consolidation can bring about lower prices and increased competition. I assume you wouldn't disagree with either of those statements.
No, Senator.
As you know, and as several of my colleagues have mentioned, President Trump signed into law the First Step Act about a month ago. This is legislation that I applaud and legislation that I've been working on in one way or another for 8 years, and was pleased to team up with Senator Grassley, Senator Durbin, Senator Booker, and others to work on that over the course of many years. As you know, the Attorney General has an important role under the First Step Act in appointing members to something called the Independent Review Commission. That Independent Review Commission will make recommendations concerning which offenders might be eligible for earned credits under this legislation and which programs will be approved. When we drafted this legislation, there were some members who were concerned that whoever was the Attorney General at the time of this law's passage and implementation might be able to undermine the effectiveness of this law by appointing members who didn't agree with or believe in the objectives of the bill. So will you commit to me, Mr. Barr, that you will appoint people to that Independent Review Commission who are honest brokers to decide which offenders should be eligible and which programs should be eligible to participate?
Yes, Senator.
Thank you. You familiar with the Ashcroft-Sessions policy, namely the policy requiring prosecutors to charge the most significant readily provable offense?
Yes, Senator.
Tell me how that should best be balanced out with the discretion of a prosecutor, most frequently, of course, with the discretion of a local U.S. Attorney's office.
Well, I was going to say, I think the best way of balancing it out is to have a supervisor who is able to approve departures from that policy based on the specific circumstances. And there are countless different, permutations of facts that might justify a departure from it. So I think it's best handled by supervisory people. But I also think it has to be looked at centrally. I'm not saying that each case has to be approved centrally, but there has to be some monitoring of what's going on because, as you know, one of the things that led to the sentencing guidelines was, just big differences in the way the laws were being applied and enforced around the country. And I think we need to try to strive for as much uniformity as we can.
But you intend to continue that policy?
Yes.
And
unless someone tells me a good reason not to.
If I'm understanding you correctly, you're saying that if you do follow it, you will defer to the judgment of the office in question in the case of determining when to not charge the most serious readily provable offense.
No, I won't defer to my subordinates. I'm not going to say, I will defer to my subordinates. Usually you do defer to your subordinates, but there might be a case I disagree with, and I'll assert myself on it.
Okay. I see my time has expired. Thank you, sir.
Thanks, Senator Lee. We'll take a recess to 12:15 and start with Senator Whitehouse when we come back. Go ahead.
Hey, it's great to see you. I know. Just give me the high side. That's my phone. Okay. Well, they'll probably bring it. No, that's okay. You're in the room. That's okay. I'm going to leave anything in the hotel. Come back. Okay. Well, the picture is in the state. There's one here at the press. We're here till 10:30 tonight anyway, so it doesn't matter what time it is. That's my shift, so. Front row is reserved, so you only have these back three.
Okay. Right now, I just wide open stuff. The little stroke around. Yeah, but there's still plenty of. I think they. Oh, she was in the way she's. Yeah. Oh, did he have the kick test? Maybe that was better. Sometimes I do buckle over. He's just more outgoing. He made advanced gym under. He can do the fundamentals. So he could. He's already decent. He's like it. He's good. But he just not interested in like competition. You do. Either have it or you don't. So it's better he doesn't do it. Yeah. It's just he just go out there and stay. Oh, were you really? That's great. Okay. You get together further, right? So doing just better. I know. No, I did. Brother. Let me know. I'll probably come over anyway after the election.
a mixed bag.
The hearing will come to order, and I recognize Senator Whitehouse. Thank you, Mr. Barr.
Thank you, Chairman. This is my first chance at a committee hearing to congratulate you on taking the gavel here. We worked well together when you were chairman of the Crime and Terrorism Subcommittee, and I hope that that will continue here. Mr. Barr, welcome. Did you make it a condition of taking this job that Rod Rosenstein had to go? Just to be clear, so we're not bandying words here, did you request or signal or otherwise communicate in any way that you wanted Rod Rosenstein to go?
No, the president said that the decision on the deputy was mine. Anything I wanted to do on the deputy was
So
fine.
we will find no William Barr fingerprints on Rosenstein's departure.
No, Rod and I have been talking, about his plans. He told me that he viewed it as a 2-year stint and would like to use, if I'm confirmed, my coming in as an occasion to leave. But we talked about the need for a transition, and I asked him if he would stay for a while, and he said he would. And so as of right now, I would say he has no concrete plans. I have no concrete plans in terms of his departure.
And you have not
we're going to sort of
undertaken-
play it by ear and see what makes sense.
And you have not undertaken to run him out in any way?
Absolutely not.
That leaves an opening at the DAG position whenever you work this out. Can you tell us, since attorneys general are very often defined by the immediate appointments around them at chief of staff, DAG, criminal chief, what are the characteristics and qualifications that you will seek as you fill particularly that position, but all three that I mentioned?
I'm sorry, the deputy, and what was the other
Deputy chief of staff and criminal chief.
one? There is already a criminal chief.
I know.
Yeah.
He's already a deputy attorney general, but he's leaving.
Well, for a deputy, I'd like someone who's a really good manager and who has had good management experience running government programs. And I want a first-rate lawyer and someone whose judgment I feel comfortable in.
Experience in the department?
Not necessarily, but experience in government at a high level.
When we met, I gave you a letter that you've seen, just so none of these questions would be a surprise. So I hope it is no surprise to you that I'm going through some of them. If you're confirmed, what will be the department's rule regarding communications between White House and Department of Justice officials regarding criminal and investigative matters? Who at DOJ will be allowed to have those conversations with the White House, and who at the White House will you entertain those conversations from at DOJ?
So, I've looked through the existing regime, and my instinct is to keep it, maybe even tighten it up a little bit more. I remember when George W. Bush's administration was coming in, my advice was start tight, and then as you realize who has judgment and so forth, you can go back to a...
They went the other way, and it was a bad day for Attorney General Gonzalez in the hearing room when that was brought to his attention. What is your understanding right now of who at the Department of Justice is authorized to have communications with the White House regarding
Well, it depends what it is, but on criminal matters, I would just have the AG and the deputy.
And what do you think the rule is now in the department?
I think that's what it is.
Okay. So if the reports are true that as chief of staff, Mr. Whitaker was involved in conversations with the White House about bringing criminal investigations against the president's political enemies, that would not be consistent with your understanding of that policy.
Well, it would depend upon, what his understanding is with the Attorney General.
Well, the Attorney General was recused, so hard to step into the shoes of a recused Attorney General on that matter, right?
Well, I don't know what the communication's related to. I'm not really sure what you're talking about.
Okay. Well, I hope you'll become sure when you get there, because there's a fair amount of I think, questionable behavior that has gone on that does not reflect well on the department that I hope will get your attention. I also asked you about the special counsel investigation and to give us a clear exposition of how that memo came to be, who you talked to, when, who was involved in it. There were a number of questions in that letter that at this point you have not answered. You have, I gather, told the chairman the names of some dozen or so people whom you contacted, as I understand it, once the memo was written, but it's not clear. Do you have any objection to answering the questions that I wrote as questions for the record so that the committee can understand who you worked with, who you talked with about this idea, who you worked with in preparing the memo, who helped you with things like citations that people at your level don't often do yourselves, and where it was circulated and vetted and what edits were made and so forth?
No, I have no objection to that.
Great.
But
We'll let that
just to be clear, no one helped me write the memo, and I know how to do legal citations, which I do.
Yeah, well, a lot of people know how, but that doesn't always do
I
it.
do it. I did. Okay.
You might want to get out of that habit. You may have other things to look at.
I'd like to have some fun in life.
If you think citations are fun, you're not gonna have the problem some other nominees have had. My letter to you also asked about the Bork order that set out a series of protections for the then independent counsel operation. Do you have any objection to any of those rules or principles applying, and should we see those rules and principles, which I gave to you then, as being more or less adopted into the statement that you made earlier about your protection of the Mueller investigation from political interference?
I looked at them. I think the current regime is what I'm happy with. In other words, I wouldn't change the current rule those rules were put in place at the end of the Clinton administration, and sort of, I think, reflects the back-on-back experience of the Reagan-Bush years and then the Clinton years, and then sort of Justice Department's thinking under the Clinton administration as to how to balance all the equities, and I think it's working well. So
well, if there's anything that you would disagree with in the so-called Bork rules, I'd ask you to explain that in a follow-up.
Okay.
Also in my letter to you, I expressed my concern that Mr. Whitaker was paid $1.2 million through what I consider to be a front group that has very little reality to it, and that the funding that came to that front group to pay him the $1 million came through another entity that is essentially an identity laundering operation that has no independent business operation. And the result of all of this is that somebody out there arranged to get over $1 million to Mr. Whitaker, and we have no idea who that somebody is. And as I mentioned to you in our conversation, I don't see how the department can do a proper recusal and conflict analysis for somebody when the player who delivered the $1 million is still hidden behind the curtain. Is that something that you will help us fix?
Well, first, I don't think there was anything wrong done, or
Well, we don't know that yet because we don't know what the facts are.
Yeah, well, I'm just saying, just the facts that you've said, doesn't necessarily mean there was anything wrong done. What you're saying is that if the ultimate financial backers are behind some entity and the current ethics laws require only the reporting of the entity, you're not really sure where the money is coming from. And that, I think that raises a very interesting point that I think I would like to review with the ethics people and experts and even OGE to talk about that, because the more I thought about it, the more I thought that the trick is going to be deciding what kind of entities and how far back you go, because that can be said of a lot of different kinds of entities.
Yeah.
And
I
sometimes you
would
have
submit to
first.
that if the department's money laundering folks looked at this operation, they would see it as almost amateurish and simple, and something quite easy to penetrate. And it would be quite easy simply to ask Mr. Whitaker what he knew, to ask whoever is still at fact, if it even has any existence with Whitaker's departure, what they knew, and to ask Donors Trust to cough up the identity of the donor, and then you can do your homework. And if they refuse to do that, nothing guarantees anybody a job at the highest levels of government who's not willing to provide those disclosures.
Well, as I said, one of my first considerations always is where do you draw the line, and also what are the implications for other kinds of entities? Because there are membership groups and First Amendment interests, and you don't want to disclose memberships and who's.
And my point was, I think if your money laundering folks took a look at that, they'd be able to help show that this is something that looks a little bit different than that. My time has expired, and see you on the second round. Thank you.
Senator Sass.
I believe Senator Ernst is filling in for Senator Cruz next. Thank you, Chairman.
Okay with me.
Thank you. Mr. Barr, I want to commend you for stepping forward. Thank you very much. And I want to say thank you to your family as well for being so supportive in this endeavor. I'm really pleased to have all of you here, so thank you for doing that. Mr. Barr, later this month, I do plan on reintroducing Sarah's Law, which is a bill that would require the detention of illegal aliens who have been charged with a crime that resulted in the death or serious injury, bodily injury of another person. Now that sounds pretty common sense, but I'll give you a little background. This bill is named after Sarah Root. She was a resident of Council Bluffs, Iowa, and Sarah was killed by an illegal alien who was driving drunk. And that alien had a blood alcohol content of more than 3 times the legal limit, yet he was allowed to post bond and has not been seen since. It's important to me that Congress act to close these loopholes in our immigration system and do better to enforce the laws that are already existing on the books. And I know that Attorney General Sessions, he had a real passion for this, and he had a strong record of trying to make sure that we're correcting wrongs in the system. How do you, as Attorney General, plan on making sure that we are restoring the rule of law in our immigration system?
Well, first, that sounds like a very commonsensical bill and something that I would certainly be inclined to support. I think one of our major problems, as the president says, is that the immigration laws just have to be changed, and to provide sensible and common sense ways of processing immigration and claims of asylum. Right now, this goes all the way. This goes back 27 years. We were facing exactly the same kind of problem, maybe on a smaller scale. But Congress has to, where people are abusing the asylum system, coming in, they're being coached as to what to say, and then once they come in, we don't have the facilities to keep them, and they're released into the population. And this was a big abuse, as I say, 27 years ago, and it's gotten worse. So we need to change the laws to stop that kind of abuse and enable us to run a lawful immigration system where we process people into the country who are entitled to come into the country, and we keep out those that are flouting our laws. And it's long overdue. And the president is right that until we're able to do that, we're just not going to be able to get control over illegal immigration, and it creates a lot of unsafe conditions for many people.
Absolutely, and I appreciate your thoughts on that. This is a very important issue. I think all of us understand that immigration is so vital to our country, but it has to be done in the right manner. And for those that are causing bodily injury and death to those here in the United States, we want to make sure that they are brought to justice. And in this case, that illegal, undocumented was not brought to justice. And I feel a lot of empathy for that family. I'll move into another situation that's really important to Iowans. According to the U.S. Department of Health and Human Services, after drug dealing, human trafficking is tied with arms dealing as the second largest criminal industry in the world, and it generates about $32 billion each year. The Department of Justice has said that 83% of sex trafficking victims identified in the United States are U.S. citizens, with the average age of a victim being between 12 and 14 years. 12 and 14 years. Since 2007, there have been over 300 cases of human trafficking in Iowa alone. And Iowa is a very rural state. 300 cases. That's very concerning to my constituents back home. What do you see as the main contributor to human trafficking here in the United States? And then how can the DOJ impact and combat and prevent those heinous crimes?
This is an area that frankly wasn't very much on the radar scope of the Department of Justice when I was last there. I know it's it's an abhorrent area of criminality that I know the department and Attorney General Sessions have been focused on and have put in place various programs and entities within the department to focus on it and work with state and local law enforcement on it. I'm not sure what the major contributor to it is. It's an area that I'm going to have to study when I get into the department and see what are the factors contributing to it.
Okay, I appreciate that. And as I mentioned in my question as well, drugs and drug trafficking, that is also a very, very big industry. And in fiscal year 2017, 65% of drug-related prison sentences in Iowa were related to methamphetamine. We talk a lot about the opioid crisis, but in Iowa, it still is meth. In 2016, Iowa reported over 1,500 founded child abuse reports relating to methamphetamine being found in the child's body. According to the DEA, most of the meth available in the United States is being produced in Mexico and smuggled across our southern border. How do you see the situation at our southern border contributing to the prevalence of controlled substance use here in the United States?
Well, as been pointed out earlier, it is the major avenue by which drugs come into the country. Heroin, fentanyl, all the serious drugs are coming across that border. And again, I feel it is a critical part of border security that we need to have barriers on the border. We need a barrier system on the border to get control over the border. And I think obviously there's some places that more of the traffic comes over than others, but unless you have a system across the border, you're not going to be able to deal with it because you'll just displace it. If you build a barrier in one place, you'll just displace it to another. So we need a barrier system across the border. Part of that is illegal immigration, but a big part of it also is preventing the influx of drugs.
Mm-hmm. Absolutely. And you stated earlier that really the head of the snake lies outside of the United States. Is there a way that DOJ can be working with additional ideas, methodology with other departments that you might think would help?
Yes, this is an area, again, because I'm out of the government, I don't know how it's functioning, how the drug war is being coordinated, but I think justice can play a big role in pushing for partners like the State Department, Defense Department, the intelligence agencies, and so forth to help deal with this. It's not, to me, not just a law enforcement problem, it's a national security problem.
Mm-hmm. And you mentioned as well the situation on the border where we do need barriers in place to control the influx of whether it's drugs, human trafficking, gun trafficking, so forth. Do you believe that sanctuary cities play a role in harboring some of those activities?
Yes, I do. I think there are a number of sort of, of factors that have a hydraulic effect in that they pull people into the United States or induce them to take the hazards of coming into the United States and coming up hundreds of miles through Mexico and so forth. And things like sanctuary cities where they feel that they'll be able to come up and hide and be protected is one of those factors that I think is irresponsible because it attracts the illegal aliens coming in. Obviously, I think that the main problem with sanctuary cities is that they're not giving us information about criminals that they have in their custody. This is not chasing after, families or anything like that. This is going after criminals who the state local law enforcement have in custody, and not allowing us to take custody of them and get them out of the country. That's the problem with sanctuary cities.
Correct, which could be the situation with Edwin Mejia, who killed Sarah Root. So we would love to see that young man brought to justice. Thank you very much for your time.
Thank you. Well, just follow up on that, Senator Klobuchar. Don't count this against her time. So you're saying that you want access to people who've committed crimes or accused of committing crimes outside of a status violation. Is that what?
That's right, Senator.
Senator Klobuchar.
Thank you. Thank you, Mr. Barr. I take it as a positive that your grandson has gotten out a pen and a pad of paper to take notes during my questions. I am also impressed by your daughters and that they all chose to go into public service. But as you know, employees at the Justice Department now are either furloughed or they are working without pay. And I have talked to a number of them at home, and it's an outrage. Very briefly, what do you have to say to them?
I would like to see a deal reached whereby Congress recognizes that it's imperative to have border security, and that part of that border security, as a common sense matter, needs barriers.
And you're aware that in the comprehensive Senate immigration bill that we passed, there was literally billions of dollars for border security back in 2013?
I'm generally aware of that.
And that also we had an agreement earlier last year which would allow the Dreamers to stay legally, that also had money for border security?
The point is, we need money right now for border security,
we have-
including barriers and walls and slats and other things, anything that makes sense in different areas of the border.
In different areas. That's a good point. So President George H.W. Bush said back in 1980 that he didn't want to see 6- and 8-year-old kids being made to feel that they're living outside the law, and you were his attorney general. He also said that immigration is not just a link to America's past, but it's a bridge to America's future. Do you agree with those statements?
Yes, I think, as I said, I think legal immigration has, we have a great system potential. I think it needs reforming, but legal immigration has been good for the United States. It's been great for the country.
And that's why we were trying to work on that comprehensive reform. I want to just briefly turn to FBI leadership. The president has made statements accusing the FBI of making politically motivated decisions. Many of us up here and in the Senate have confidence in Director Wray and the leadership at the FBI and believe they can do their jobs without politics getting in the way. Do you agree with that?
I'm looking, if I'm confirmed, I'm looking forward to getting to know Chris Wray. From what I know, I think very highly of him.
Okay, thank you. In the memo from back in June, the one comment that Senator Grassley made, he talked about how much the Mueller investigation was costing, and I actually did a little Googling here, and there was a CNBC report that it actually could bring in more money than it cost because of the wealthy people being prosecuted, that Manafort's assets could be well over $40 million. I don't know if that includes that ostrich jacket, but Do you think that's possible based on your experience with white-collar crime?
I don't know enough about it.
Okay. In your memo, you talked about the Comey decision, and you talked about obstruction of justice, and you already went over that, which I appreciate. You wrote on page 1 that a president persuading a person to commit perjury would be obstruction. Is that right?
Yes.
Okay.
Or
and-
any person who persuades
person.
another to, yeah.
Okay. You also said that a president or any person convincing a witness to change testimony would be obstruction. Is that right?
Yes.
Okay. And on page 2, you said that a president deliberately impairing the integrity or availability of evidence would be an obstruction. Is that correct?
Yes.
Okay. And so what if a president told a witness not to cooperate with an investigation or hinted at a pardon?
You know, I'd have to know the specific. I'd have to know the specific facts.
Okay. And you wrote on page 1 that if a president knowingly destroys or alters evidence, that would be obstruction.
Yes.
Okay. So what if a president drafted a misleading statement to conceal the purpose of a meeting? Would that be obstruction?
Again, you know, I'd have to know the specifics.
All right. You would seek the advice of career ethics officials in the Department of Justice for any recusal, and I appreciate that. And you said in the past that you commended Attorney General Sessions for following the advice of those ethics lawyers, but you didn't commit today to following that advice. Is that right?
No, I didn't commend him for following the advice. As the agency head, he makes he's the one responsible for making the recusal decision. I don't know why he locked himself into following the advice. That's an abdication of his own responsibility.
So what did you think about what Acting Attorney General Whitaker did when he rejected the Justice Department ethics advice to recuse himself out of an abundance of caution?
I haven't seen the advice he got, and I don't know the specific facts. But abundance of caution suggests that it could have gone either way.
You've committed to recuse yourself from matters involving the law firm where you currently work. Are you aware of any of your firm's clients who are in any way connected to the special counsel's investigation?
I'm not aware. To tell you the truth, I'm of counsel there, and I have one client which I'm representing, and I don't pay very much attention to.
Well, you
what
can
else
also
is going on.
supplement that.
Yeah,
in
I'll supplement
Okay,
my
no
answer.
problem. Will you commit to make public all of the report's conclusions, the Mueller report, even if some of the evidence supporting those conclusions can't be made public?
You know, that certainly is my goal and intent. It's hard for me to conceive of a conclusion that would, run afoul of the regs as currently written, but that's certainly my intent.
Secure elections, you and I had a talk about that in my office. Do you think backup paper ballots are a good idea? This is a bill that Senator Langford and I have introduced, and with Senator Graham and Senator Harris.
Yeah, I don't know what's a good idea, what's a bad idea right now, because I haven't gotten into this area, but.
Okay, well, I'll just tell you backup paper ballots is a good idea.
Okay.
And we can talk about it later, as well as audits along the lines of voting. State election officials in North Carolina, as you know, contacted the Justice Department about the integrity of their elections. The Justice Department may have failed to take action in a timely manner. What steps would you take to make sure these failures don't occur again?
Not specifically with respect to North Carolina, you're talking generally. Yeah. Well, as I say, I want to make one of my priorities the integrity of elections. And so this is not an area I have been involved with deeply before. And when I get to the department, if I'm confirmed, I'm going to start working with the people and making sure that those kinds of things don't happen.
Part of this, of course, is also voting rights and our concern about some of the changes in department policy. And I hope you will seriously look at that, because the last thing we should be doing is suppressing voting, and that is what we've been seeing under this current administration. My dad was a reporter, so I grew up knowing the importance of a free press. We obviously have the tragic case of a journalist who worked right here at the Washington Post, Jamal Khashoggi, and it's a particular concern. So I want to ask you something I asked Attorney General Sessions. If you're confirmed, will the Justice Department jail reporters for doing their jobs?
I think that, I know there are guidelines in place, and I can conceive of situations where, as a last resort, and where a news organization has run through a red flag or something like that, knows that they're putting out stuff that will hurt the country. There might be there could be a situation where someone would be held in contempt,
Well,
but
Attorney General Sessions had said he was going to look at potentially changing those rules at one point, so I'd like you to maybe respond in writing to this, because that was very concerning. And when you and I were in my office, we talked about your work with Time Warner with this major merger on appeal from the Justice Department, and I just wanted you to commit today to what you committed to me in the office, that you would recuse yourself from any matters regarding that appeal.
absolutely.
Okay? And as you know, you were on the board of Time Warner at the time, and you signed a sworn affidavit questioning whether the Justice Department's decision to block the merger was politically motivated, given, and this is from the affidavit, the president's prior public animus towards the merger. Are you talking here about his view on CNN? What did you mean by prior public animus?
I'm sorry, could you repeat that?
Sure.
Yeah.
You were on the board of Time Warner, and you signed a sworn affidavit questioning whether the Justice Department's decision to block the merger was politically motivated, given the president's prior public animus toward the merger. And so what did you mean by that?
I mean, the affidavit speaks for itself in that at that meeting, I was concerned that the Antitrust Division was not engaging with some of our arguments, and I got concerned that they weren't taking the merits as seriously as I would hope they would. But I have no, I'm not sure why they acted the way they did.
Okay, very good. And I'll ask you more on antitrust policy-wise in the second round, and I appreciated the discussion we had on that. It's very important. Okay. Thank you very much. Yeah.
Thank you. Senator Hawley did a good thing by allowing Senator Ernst to go, because she had no good deed goes unpunished around here, but you do have a credit with the chairman, so I appreciate that. Senator Cruz, you're next.
Thank you, Mr. Chairman, and thank you, Senator Hawley, as well, and welcome to the committee. Welcome to all the new members of the committee, and congratulations, Mr. Chairman. We are looking forward to the Lindsey Graham chairmanship of Judiciary, and I'm sure
They'll make a movie about it, I'm sure.
I am certain whatever else happens, it will not be boring. Welcome, Mr. Barr. Congratulations on your nomination yet again. And let me say thank you. You and I have visited before about this, but the past 2 years have been a difficult time at the Department of Justice. And you and I and many on this committee hold the Justice Department in very high esteem. Indeed, I would even say revere the department and its century-long tradition of enforcing the law without regard to party and without regard to partisanship. And I commend you for your willingness to go back and serve once again. I think that is a good step for the department and a good step for strengthening the department. You know, I would note 27 years ago, when you did this previously, when you were last nominated to be Attorney General, when I think you may have been about Liam's age at the time, it was a different time. Then Chairman of the Judiciary Committee, Joe Biden, said at the time that he found you to be, quote, honest, and that you, quote, understand and are committed to the dual responsibility of the Office of the Attorney General. Chairman Biden also said that, quote, this commitment to the public interest above all else is a critical attribute in an Attorney General, and I will vote to confirm Mr. Barr. Senator Ted Kennedy likewise noted your dedication to public service. Senator Fritz Hollings said, quote, Mr. Barr has a distinguished academic background and impressive experience in private sector as well as in public service. Most important, Bill Barr is a known quantity. He has done a truly outstanding job as Deputy Attorney General for the last year and a half, during which time he has worked with many of us in this body, earning our respect for his professionalism and competence. And Senator Cole said that, quote, your willingness to discuss the issues is a refreshing change in the confirmation process, and it would be wise of future nominees to follow Mr. Barr's example. At that hearing, you were confirmed by this committee unanimously, as you had been twice previously for senior appointments to the Department of Justice. Now, we all recognize that was a different time. I think given the environment we are in now, few expect this committee vote to be unanimous. But I would hope those voices from the past, from Democrats who were respected by members of this committee, will be heard today as well. One of the questions you were asked, if I might paraphrase, was, why on earth would you take this job? And your answer, if I recall correctly, concerned your commitment both to the department and the rule of law. Would you tell this committee, in your judgment, why the rule of law matters? Why is that important?
Well, you know, as our framers said in the Federalist Papers, the art of setting up a government is to have a government that's strong enough to perform the functions that a government has to perform, while at the same time not being so strong that it can oppress its own people. And the rule of law ensures that precisely that the government does not oppress its own people. And when people are accused of wrongdoing, our system essentially gives them the benefit of the doubt and gives them rights to bring them up essentially to the same level as the government. And the process we go through is there to ensure that justice is not arbitrary, but it's done according to a set of rules. And the basic protection that we have is that the rule that applies to one applies to all. That, at the end of the day, is what keeps us all free. That is the protection of individual freedom. And to me, the rule of law is exactly that we don't allow special rules to go into effect for a particular individual. A rule has to be universalized. Anything we do against A has to be universalized across everyone who's similarly situated. That's our basic protection, and to me, that's what the rule of law is.
So I don't want to see a Republican Department of Justice or a Democratic Department of Justice. I don't want to see a Republican FBI or a Democratic FBI. What we should see, what the American people have a right to see and a right to expect, is a Department of Justice that is committed to and faithful to the Constitution and the laws, regardless of political party. And a corollary to that is a department that is willing to hold anyone who commits criminal conduct accountable, regardless of that individual's political party or whatever partisan interest there might be. Would you agree with that characterization?
Senator. Yes, Senator.
I would note as well, during the previous administration, there was concern by many, including me on this committee, that the previous administration, and in particular the IRS, had targeted individual citizens and citizen groups for exercising their First Amendment rights and had abused its power in doing so. The current Justice Department I've been dissatisfied with the degree of scrutiny they have given to that potential abuse of power. And I'm going to ask you going forward, if you are confirmed, to examine that conduct and ensure that if laws were broken, that individuals are held accountable. Let me shift to a different topic. One of the most important safeguards of our liberties is the Bill of Rights. And the Attorney General has a unique responsibility defending the Constitution. Can you share for this committee, in your view, the importance of free speech, of the protections that the First Amendment provides to Americans to speak, and even to speak on unpopular or politically disfavored topics?
I think free speech is at the core of our system because we believe in the democratic process and power shifting through the processes of voting by an informed electorate. And free speech is foundational to the ability to have a democratic process. The framers, I think, believe that the dialectic, the clashing of ideas in the public marketplace, is the way to arrive at the truth. And that is one function. Another function of free speech is that it's the substitute for other means of settling differences. In some ways, it's a safety valve. People are allowed to speak their mind and persuade their neighbors of their position. And I think that performs a very important function in keeping the peace within a community. And if speech is suppressed, it can lead to the building up of pressures within society that sometimes can be explosive.
How about your views on religious liberty? And would you share your thoughts on the importance of the religious liberty protections in the First Amendment in terms of protecting our diverse and pluralistic society?
Yes, I think the framers believe that our system, they said that our system only works if the people are in a position to control themselves. Our government is an experiment in how much freedom we can allow the people without tearing ourselves apart. And they believed fewer laws, more self-control, and they believed that part of that self-control, and I know there are many people here who disagree, in our society, not here, but in our society who disagree, but they believe part of that self-control ultimately came from religious values. And I think it's important underpinning of our system that we permit. I believe in the separation of church and state, but I am sometimes concerned that we not use governmental power to suppress the freedoms of traditional religious communities in our country.
Final question. The Department of Justice is charged with defending the United States, but that doesn't mean that the Department of Justice always must argue for maximum federal power. There are important restraints on federal power, whether civil liberties protections in a criminal context, whether the Takings Clause, or whether the 10th Amendment and federalism. Can you briefly share your thoughts on the appropriate balance of respecting the limitations on federal power?
Well, as you say, the Constitution has many different forms of restraint on federal power. Part of it is, in fact, the separation of powers within the federal government. Part of it is the balance between the federalist system we have and the central government, and respecting the rights of the states and local communities. And part of it is the Bill of Rights that on certain topics constrains the role of the federal government. And those are all important checks on federal power. And, I am concerned about our country becoming just a unitary state that we try to govern centrally, 350 million people. I think a lot of our current tensions in society are because we are turning our back on the federalist model. There are certain things that have to be protected by the federal government. There's no ifs, ands, or buts about that. But the more we can decentralize decision-making, the more we can allow people a real diversity in the country of approaches to things, I think we'll have less of an explosive situation.
Very much agree. Thank you, Mr. Barr.
The freedom of speech has to be balanced by the freedom to question. Senator Coons.
Congratulations, Chairman Graham. I look forward to working with you in this Congress, and thank you, Mr. Barr, and to you and your family for their service to our country through federal law enforcement and the Department of Justice. You just faced some questioning from Senator Cruz about your own confirmation hearing back in 1991, and I'd like to take us back to a previous confirmation hearing, which was at a more similar time to today than 1991, 1973. Senator Leahy asked you about the confirmation of Elliot Richardson, President Nixon's nominee to be Attorney General. That confirmation took place in the context of a similarly divided period in American history where there was great concern over the, at that point, ongoing Watergate investigation. And Elliot Richardson reassured the country by making some important commitments during his confirmation hearing before this committee. Then Senator Strom Thurmond asked Richardson if he wanted a special prosecutor who would, and I quote, shield no one and prosecute this case regardless of who was affected in any way, shape, or form. Richardson responded, exactly. Do you want Special Counsel Mueller to shield no one and prosecute the case regardless of who is affected?
I want Special Counsel Mueller to discharge his responsibilities as a federal prosecutor and exercise the judgment that he's expected to exercise under the rules and finish his job.
Senator Kennedy followed up by asking Richardson if the special prosecutor would have the complete authority and responsibility for determining whom he prosecuted and at what location. Richardson said simply, yes. Would you give a similar answer?
No, I would give the answer that's in the current regulations, which is that the special counsel has, broad discretion, but the acting attorney general in this case, Rod Rosenstein, can ask them about major decisions, and if they disagree on a major decision, and if after giving great weight to the special counsel's position, the acting attorney general felt that it was so unwarranted under established policies that it should not be followed, then that would be reported to this committee.
Forgive me, I've got 7 minutes left. I have a number of other questions. Let me just make sure I understand you. Senators asked Elliot Richardson what he would do if he disagreed with the special prosecutor. Richardson testified to the committee the special prosecutor's judgment would prevail. That's not what you're saying. You're saying that if you have a difference of opinion with special counsel Mueller, you won't necessarily back his decision. You might overrule it.
Under the regulations, there is the possibility of that, but this committee would not, would be aware of it. A lot of water has gone under the dam since Elliot Richardson, and a lot of different administrations on both parties have experimented with special counsel arrangements.
Well,
and the existing rules, I think, reflect the experience of both Republican and Democratic administrations and strike the right balance. They are put together in the Clinton administration after Ken Starr's investigation.
That's right. So the current regulations on the books right now prevent the Attorney General from firing without cause the special counsel. They require misconduct, dereliction of duty, incapacity, conflict. Will you follow that standard?
Of course.
What if the president asked you to rescind or change those special counsel regulations?
I think those special counsel regulations should stay in place for the duration of this investigation, and we can do a postmortem then, but I have no reason to think they're not working.
So most famously, when directed by President Nixon to fire the special counsel, the prosecutor investigating Watergate. Richardson refused and resigned instead, as we all well know. If the president directed you to change those regulations and then fire Mueller, or simply directly fired Mueller, would you follow Richardson's example and resign instead?
Assuming there was no good cause?
Assuming no good cause.
I would not carry out that instruction.
Let me bring us forward to your 1991 hearing in front of this committee. You explained at the time how you would handle the BCCI case, and ironically, Robert Mueller, the same individual, was at that point the head of the criminal division. And you testified that you had directed Mueller to spare no resources, use whatever resources are necessary, and pursue the investigation as aggressively as possible and follow the evidence anywhere and everywhere it leads. Would you give similar direction to Robert Mueller today?
I don't think he needs that direction. I think that's what he's doing.
You also said at that hearing that Robert Mueller in that investigation had full cooperation, full support, and carte blanche. Could he expect a similar level of support from you as Attorney General?
Yeah, he will. As I said, I'm going to carry out those regulations, and I want him to finish this investigation.
I think we all do. And I am encouraged by things you've said about this and just want to make sure we've had as clear a conversation as we can. Attorney General Richardson also testified the relationship between the President and the Justice Department should be arm's length. You've said similar things about the importance of shielding the department from political influence. Can you make a similar commitment to us to maintain an arm's length relationship between the Justice Department and the President regarding the special counsel investigation and other investigations?
Yeah, well, remember I said that there are like 3 different functions generally that the Attorney General performs. I think on the enforcement side, especially where matters are of either personal or political interest to people at the White House, then there has to be an arm's length relationship. The White House counsel can play a constructive role in that as well.
Let me ask, if the President asked for information that could well be used to interfere with the special counsel investigation, to misdirect or curtail it in some way, would you give it to him?
No, I mean, there are rules on what kind of information can flow and what kind of communications can go between the White House, and I would follow those. But the basic principle is that the integrity of an investigation has to be protected. There are times where you can share information that wouldn't threaten the integrity of an investigation, like, for example, when I was Attorney General and we were investigating something that related to someone who had a relationship with President Bush, I could just orient them that, there's going to be a story tomorrow that says this, but in that particular case, there was no chance that it would affect the investigation. So sometimes judgment calls are necessary.
If you learn that the White House, not directly through you, but through other means, was attempting to interfere with the investigation, would you report that information to the special counsel and to Congress?
Well, there's some conclusions in there about interfering, and if I thought something improper was being done, then I would deal with it as Attorney General.
Last, in that confirmation hearing back in 1973, then Senator Birchby of Indiana asked Richardson, suppose the prosecutor determines it's necessary to get the president's affidavit or to have his testimony personally. Would that be the kind of determination he, the special prosecutor, could make? Richardson said, yes. Will you give a similar answer today that you won't interfere with Special Counsel Mueller seeking testimony from the president?
I think, as I say, the regulations currently provide some avenue if there's some disagreement. I think that in order to overrule Mueller, someone would have to the Attorney General or the acting Attorney General would have to determine, after giving Mueller's position great weight, that it was so unwarranted under established policies that it should not be done. So that's the standard I would apply. But I'm not going to surrender the regulations give some responsibility to the Attorney General to have this sort of general not day-to-day supervision, but sort of be there in case something really transcends the established policies. I'm not surrendering that responsibility. I'm not pledging it away.
What gives me pause and sort of led me to this line of questioning, Mr. Barr, was that June 2018 memo you sent to the Deputy Attorney General, in which at one point you state Mueller should not be permitted to demand the President submit to interrogation about alleged obstruction. If the special counsel wants to subpoena the President's testimony to ask questions about obstruction, and you're supervising the investigation, would you rely on that theory to block the subpoena?
Well, the question for me would be, what's the predicate? And I don't know what the facts are. I don't know what the facts are. And if there was a factual basis for doing it, and I couldn't say that it violated established policies, then I wouldn't interfere. But I don't know what the facts are.
Well, if I might, just in closing, Mr. Chairman, we're in this unique situation where you've known Robert Mueller 30 years. You've said you respect and admire his professionalism, his conduct. He's been entrusted by you with a significant, complex investigations in the past. There's no reason to imagine, since he is the person who would know the facts, that he wouldn't be acting in an inappropriate way. So it is my hope, even my expectation, that you would trust Robert Mueller to make that decision about whether to compel the President to testify in an appropriate way and that he would not face any interference. Thank you for your testimony today. I look forward to our next round.
Senator Sass.
Thank you, Mr. Chairman, and congratulations on your new calling here. Liam, I have career advice. I won't do it on camera. We want to know if you're taking notes for your cousins about career advice, though. We'll ask you later. General, congratulations on your nomination. And thanks for your past service. I had planned to ask you for some pledges related to the Mueller investigation in private to me, in public today. I think you've already done that. How should the American people think about what the Mueller investigation is about?
I think that there were allegations made of Russian attempts to interfere in the election, and there were allegations made that some Americans were in cahoots with the Russians, and the word is now that's being used is collusion. And as I understand it, Mueller is looking into those allegations.
A lot of the media summary of the investigation starts with people's views and who they voted for in the 2016 presidential election. And for those of us who spend a lot of time reading intelligence reports, a handful of us on this committee are about to leave to go to an intelligence briefing. What Russia is doing to the U.S. is big and broad and not constrained to the 2016 election. And increasingly, it feels like the American people reduce Russia to just how you thought about the 2016 presidential election. So since you'll have serious supervisory responsibilities over parts of the intelligence community, is Putin a friend or a foe? And what are his long-term objectives toward the U.S.?
Well, I don't hold myself out as a foreign policy expert, but I think that he is. I think the Russians are a potent rival of our country, and his foreign policy objectives are usually directly contrary to our goals. I think he wants to weaken the American alliances in Europe, and he also wants to become a player in the Middle East, more of a player in the Middle East. A lot of his foreign policy objectives are at odds with ours. At the same time, I think the primary rival of the United States is China. I think, Russia is half the size it was when we were facing them at the peak of the Cold War. Their economy is long-term prognosis is nowhere near China's. I also feel that part of what Russia's up to is trying to hold on to Ukraine and Belarus in their orbit. But I'm concerned that the fixation on Russia not obscure the danger from China.
I want to ask you some China questions as well. I want to ask about your role on the President's Intelligence Advisory Board, but sticking with Russia for a minute. Does Putin have any long-term ideological alignment with the U.S., or does he have other objectives trying to sow discord broadly here?
I'm not an expert on this area, but I think there are I think there may be some potential areas where our interests could be aligned.
But when he interferes here, does he have long-term interests in the success of one or another political party, or does he have specific interests in sowing chaos and discord to make Americans distrust one another? And one of the reasons I ask is because I'd love to have you say in public some of what you said to me about at the end of this investigation, what happens next? Are you concerned that when the Mueller report is received, quite apart from the narrowest pieces, you know where I'm headed?
Yeah. So, I mean, I think that the basic vulnerability of the United States in the age in which we live, the internet age, the globalization of information and so forth, is the vulnerability of that we're seeing, which is people can create doubt, undercut confidence in our election process, and also torque our public discourse in ways that we find hard to perceive. And this has long-term danger for the United States and the survival of a democratic society like ours. And so I hope that whatever the outcome of the Mueller investigation, that we view this as a bigger problem of foreign interference in our elections, which is why I said it was one of my priorities. And it's not just the Russians, it's other countries as well. And we have to focus on that. We have to ensure that we're doing all we can. And I'm not sure all of that is defensive either. I mean, in terms of law enforcement, I think we have to look at all options, including sanctions and other options to deter organized efforts to interfere in our elections.
So you have no reason to doubt any aspect of the intelligence community's composite assessment about Russian efforts in the 2016 election?
I have no reason to doubt that the Russians attempted to interfere in our election.
And Dan Coates, the National Intelligence Director, has testified in public and has said in different media contexts that Russia is already plotting for the 2020 elections in the U.S. You have no reason to doubt that.
I haven't, I haven't seen those reports. I had reviewed the reports about the 2016, but I have no reason to doubt it.
And can you explain what your role is on the President's Intelligence Advisory Board?
Yeah, I'm actually a consultant. I'm an advisor on sort of legal issues. Obviously, I'm stepping down from that position if I'm confirmed, but I've been just advising. I'm not a member of the board. I'm on the CIA's External Advisory Board, and have been participating on that as well.
When you talk about the long-term Chinese efforts to also sow different kinds of discord in the U.S., obviously not crossing any classified lines here, but long-term interests that other countries have in strategic rivalry with the U.S. to use gray space and information operations warfare against us. How do you see the role of the National Security Branch and the FBI more broadly fitting into the larger IC, and what responsibilities do you see would be on your priority list as you arrive at the department?
Well, I've been out of the department for so long. I'm not really sure about how that is currently being handled. I also think that we've had our attention focused on terrorism, which we can't let up, but I want to make sure that, and I'm sure Chris Wray is on top of this, and looking forward to talking to him about it, of making sure that the Bureau is playing a central role in combating efforts by foreign countries to engage in those kinds of hostile intelligence activities.
You have unpacked a couple of times today the three different roles or functions of the Attorney General. Could you do that one more time in summary? And then I want to ask you a particular question. What are those three roles as you see them?
I see the three roles. In 1789, the first to set up the office, the first role was providing advice to the president and the cabinet and representing the United States in cases before the Supreme Court. And I see the three roles as providing advice, being a policy advisor on legal and law enforcement policy issues, and the top law enforcement officer enforcing the laws.
And so in no way would the job of protecting the president be a subset of any of those three jobs? The language of protecting the president has been used occasionally in this administration to refer to the way it was conceived of how Eric Holder did his job. Is there any sense in which it's the Attorney General's job to protect the president?
No, that wasn't included in my description of the role of the Attorney General. Obviously, as in the policy arena, the Attorney General is someone who should be sympathetic to the administration and its policy goals.
But there are circumstances where those three roles could come into some internal conflict, or you could be asked to do things that don't align with them. And there's probably a list that you have. I want to ask you to enumerate it here. But there's probably a list of issues where you could imagine needing to resign because of what you were asked to do in the space of so-called protecting the president.
If I was ever asked to do something that I thought was unlawful and directed to do that, I wouldn't do it, and I would resign rather than do it. But I think that should be true of every officer who serves anywhere in government, whatever branch.
I am at time, but I had a series of questions related to some of what Senator Ernst did about Sarah's Law. She and I have jointly been active in that space. The tragic case of the young woman that she was talking about from Council Bluffs it occurred in Omaha, and Edwin Mejia, her killer, is still at large, and both the last administration and this administration have not prioritized that enough in our understanding, and I imagine that Senator Ernst and I will follow up with a letter to you on that as well. Thank you.
Senator Blumenthal.
Thanks, Mr. Chairman. I congratulate you, and I look forward to working with you, and congratulate also the new members of our committee that have joined us. And thank you very much, Mr. Barr, for being here today, for your past record of public service. And I hope I am perhaps the last to make reference to your grandson by saying that if he makes it through this hearing today, he can have any job he wants in this building. Let me say first that as a former United States Attorney, I share your allegiance and admiration for the Department of Justice, and equally so, the Federal Bureau of Investigation. And I know that you respect Mr. Wray, the current director, but I think you would agree with me that the FBI is probably one of the best, if not the most professional, accomplished, skilled, and dedicated law enforcement agencies in the world. Would you agree?
Yes, Senator.
And I hope that the president agrees with you and perhaps shares that view more publicly in the future. When the FBI begins a counterintelligence investigation, if it is of the President of the United States for working with a foreign adversary, that decision would be subject to multiple levels of review within the FBI, correct?
I assume. I don't know what rules were in effect at the time.
Well, in your experience,
yes,
there would be.
Yes. And
you have no reason to think that those rules have changed.
I don't know what the practice was. There was,
and almost certainly in that kind of extraordinary investigation, you would agree with me, it would be extraordinary for the FBI to be investigating the president for working with a determined foreign adversary. There probably would be information shared with the Deputy Attorney General or the Attorney General. Agreed?
I would hope so. The reason I'm hesitating is because, some of these texts that we've all read are so weird and beyond my experience with the FBI. I don't know what was going
Well,
on.
these reports are stomach churning in terms of the absolutely stunning and unprecedented kind of investigation that they reflect. You'd agree?
You mean the texts are stomach turning?
The reports of the investigation of the president.
I'm not sure what you're talking about when you say the reports of the investigation.
The reports that the FBI opened an investigation of the president for working with a foreign adversary, Russia.
And what's stomach churning about that? What is stomach churning? The allegation against the president, or the fact
that kind of allegation would be made and be under investigation? Well, let me move on. Yeah. I want to talk about transparency. Will you commit to this committee that you will not allow the president or his attorneys to edit or change the special counsel report before it is submitted to Congress or the public?
I already said that I would not permit editing of my report, whatever report I or whoever is the Attorney General makes.
And will you commit that you will come to Congress and explain any deletions or changes that are made to that report before it is issued?
Okay, so there are different reports at work here. Which report are you? There are two different reports.
The special counsel report.
Okay, well, under the current regulations, the special counsel report is confidential. And the report that goes public would be a report by the Attorney General.
Will you commit that you will explain to us any changes or deletions that you make to the special counsel report that's submitted to you in whatever you present to us?
I will commit to providing as much information as I can consistent with the regulations. Are you saying, for example, that if information is deleted, that would be like for classification purposes, I would identify that and things like that?
Well, that you will commit to explaining to us what the reasons are for your deleting any information that the special counsel includes that you are preventing us or the public from seeing.
That would be my intent. I have to say that the rules, I don't know what kind of report is being prepared. I have no idea. And I have no idea what Acting Attorney General Rosenstein has discussed with Special Counsel Mueller. If I'm confirmed, I'm going to go in and see what's being contemplated and what they've agreed to and what their interpretation, what game plan they have in mind.
Will you permit
But my purpose is to get as much accurate information out as I can consistent with the regulation.
Well, the regulations and rules give you extraordinarily broad discretion. And I'm hoping, and I'm asking you to commit, that you will explain to us information that you have taken out of that special counsel report. And I also want to ask you about restrictions on the special counsel. Will you commit that you will allow the special counsel to exercise his judgment on subpoenas that are issued and indictments that he may decide should be brought?
As I said, I will carry out my responsibilities under the regulations. Under the regulations, whoever is Attorney General can only overrule the special counsel if the special counsel does something that is so unwarranted under established practice. I am not going to surrender the responsibilities I have. You would not like it if I made some pledge to the president that I was going to exercise my responsibilities in a particular way, and I'm not going to make a pledge to anyone on this committee that I'm going to exercise it in a particular way or surrender it.
Will you allow the special counsel to exercise his judgment as to what resources are necessary? Will you meet those needs for resources?
That would be my expectation. I think, I mean, if you believe the media, they're sort of starting to reduce their resources, so I wouldn't expect that would be a problem.
Will you allow the special counsel to exercise his judgment as to what the scope should be? The president has talked about red lines around finances. Will you allow the special counsel to exercise his judgment about what the scope should be, even if the president says that there should be red lines?
I think the scope of the investigation is determined by his charter from the acting attorney general. And if he wants to go beyond that charter, I assume he would come back and talk to whoever the attorney general is about.
Will you impose any restrictions on other prosecutors who are also investigating the president? As you're well aware, in the Southern District of New York, the president has been named, in effect, as an unindicted co-conspirator. The Eastern District of Virginia has an investigation that's relevant to the president. Will you impose any restrictions on those prosecutors?
The Office of Attorney General is in charge of the process, with the exception of the special counsel who has special rules applicable to him, is in charge of the work of the Department of Justice.
But you have a responsibility to allow prosecutors to enforce the law.
I have the responsibility to use my judgment and discretion that are inherent in the Office of Attorney General to supervise. And I'm not going to go around saying, well, this U.S. attorney or that U.S. attorney I'm going to defer to.
Well, you referred earlier to the possibility of firing a United States attorney. Would you allow the president to fire a United States attorney and thereby stop an investigation?
I would not stand by and allow a U.S. attorney to be fired for the purpose of stopping an investigation, but the president can fire a U.S. attorney. They're a presidential appointment.
But the president should have a cause beyond simply stopping an investigation for firing a United States attorney, even if he or she is a political.
Well, as I said, I would not stand by and allow an investigation to be stopped if I thought it was a lawful investigation. I wouldn't stand by for that. But the president is free to fire his officials that he's appointed.
I want to ask a question on a different topic. You said that, and I'm quoting you, I believe Roe v. Wade should be overruled. You said that in 1991. Do you still believe it?
I said in 1991 that I thought as an original matter, it had been wrongly decided. And that was what, within 18 years of its decision? Now it's been 46 years. And the department has stopped, under Republican administration, stopped as a routine matter, asking that it be overruled, and I don't see that being turned. I don't see that being resumed.
Would you defend Roe v. Wade if it were challenged?
Would I defend Roe v. Wade? I mean, usually the way this would come up would be a state regulation of some sort, and whether it's permissible under Roe v. Wade, and I would hope that the SG would make whatever arguments are necessary to address that. I think the justices the recent ones have made clear that they consider Roe v. Wade an established precedent. It's been on the books 46 years.
And you would enforce the Clinic Access Protection Act?
Absolutely.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Barr, congratulations on your nomination. Thank you for being here. You were eminently qualified for this position when you were confirmed unanimously by this committee 27 years ago, and you are eminently qualified today. It's a pleasure to have you here. I want to start where Senator Blumenthal started as well, with the reports about the FBI counterintelligence investigation launched against the president, which I also find to be stomach-turning, though perhaps for different reasons. The New York Times report indicates that the FBI began the probe in part because they were concerned about the president's foreign policy stances, comments he made during the 2016 campaign about foreign policy, and the Republican Party's official position on the Ukraine. In your experience with the FBI, is it strange to have a counterintelligence investigation begun because members of that bureau disagree with the foreign policy stances of a candidate for president or a president of the United States?
Yes.
The Supreme Court has been unequivocal that the president in our system of government, the president possesses, and I'm going to quote now, the plenary and exclusive power as the sole organ of the federal government in the field of international relations, a power which does not require as a basis for its exercise an act of Congress. That's the very famous Curtis Wright case. To your knowledge, is that still good law?
Yes.
And do you think that was rightly decided?
Yes.
Let me ask you this. Would it concern you as Attorney General if FBI agents were making decisions about when and how to launch an investigation of an elected official if it was in order to avoid being supervised or directed by their agency leadership? Would that be concerning to you?
Yes.
As is, I might just add, reported by the New York Times. Let me switch gears and ask you about another topic that you mentioned a little bit earlier in the field when we were talking generally about antitrust. This is something you talk about things that have changed in the 27 years since you were last here. One of the things that has changed is the extraordinary concentration of power in our economy in the hands of a few corporations, no more so than in Silicon Valley, which you referenced earlier today. And I just want to ask you a little bit about that. Big tech companies like, for instance, Google and Facebook, who have drawn much attention of late, pose significant challenges not just for competition, but also for the larger issues of privacy and the free flow of ideas. The Justice Department has recently deferred to the FTC across this range of issues, and while I'm hopeful that Chairman Simons will right the course here, the FTC has perhaps too often allowed these companies, in my view, to violate privacy and maybe antitrust laws without meaningful consequences. Here's my question. What role do you think the Justice Department has working with the FTC or independently to address anti-competitive conduct, potential bias, and privacy violations by these big tech companies?
Well, obviously, competition is of central concern to the antitrust division, and you know there are, I guess, concordats that have been reached between the FTC and the antitrust division as to who has primary jurisdiction in different areas. But I would like to weigh into some of these issues. I'd like to have the antitrust support that effort to get more involved in reviewing the situation from a competition standpoint. I also am interested in the issue of privacy and the question of who owns this data. You know, it's not an area that I've studied closely or become an expert in, but I think it's important for the department to get more involved in these questions.
Just on the subject of ownership of data, as you know, Facebook is currently subject to a 2011 consent decree, as part of which it agreed not to release or share or sell personal user information without the knowledge and consent of its users. Facebook's CEO, Mark Zuckerberg, has adamantly insisted under oath as recently as April 10th of 2018 that on Facebook users have complete control, those are his words, over everything that they share. However, as I'm sure you're aware, recent media reports have indicated that Facebook in fact routinely has shared user information without users' consent or even knowledge. Now, the Justice Department has the authority to enforce the terms of the 2011 consent decree and potentially to prosecute any violation. Will you consider doing so?
Well, because that is something that I might have to get involved with and supervise if I'm confirmed, I'd rather not, you know, make any comments about it right now.
Let me ask you this. These same technology companies also control the flow of information, or at least influence it, the flow of information to consumers to an unprecedented degree. I mean, you have to go way back in American history to find any analog, back to the paper trust, to find an analog of a small group of companies that control the information and influence the news and its flow to Americans to the extent that these companies do. And there's growing evidence that these companies have leveraged their considerable market power, if not monopoly status, to disfavor certain ideological viewpoints, particularly conservative and libertarian viewpoints. Do you think the Department of Justice has authority under the antitrust laws or consumer protection laws or other laws to address bias by dominant online platforms?
I would just say generally, you know, I wouldn't think it would, you know, I'd have to think long and hard before I said that it was really the stuff of an antitrust matter. On the other hand, it could involve issues of disclosure and other implicate other laws like that.
Is there any point, do you think, at which political bias could require a response? And I'm thinking, for example, Harvard law professor Jonathan Zittrain has written how Google or Facebook, for example, could manipulate their algorithms to significantly swing voter turnout to favor a candidate of their choice. Would that sort of conduct require a response from the department?
I'd have to think about that. I'm not sure. I'd like to know more about the phenomena and what laws could be implicated by it.
Let me ask you this. The Justice Department's case against AT&T Time Warner focused on how the merged company would control or could control the distribution of information to discriminate against rival content. And I understand that you, of course, are recusing yourself from that matter. But generally speaking, do you see similar concerns regarding how dominant Silicon Valley firms could use their market power in social media or search to discriminate against rival products or services or viewpoints?
Yeah, and making clear that what I'm saying now has no application to the transaction we just talked about, and talking about the other companies, yes.
Let me ask you more broadly about the question of antitrust and mergers, and you gestured towards this earlier in your testimony. I'm increasingly worried that the department is not enforcing vigorously the antitrust statutes in many sectors of the economy, not just technology. We see, again, as you've alluded to, we see growing concentration of power in various sectors held by just a few firms. And if you look at recent trends in the department's scrutiny of proposed mergers, it's at record lows. Last year, for instance, the Department of Justice Antitrust Division scrutinized mergers through second requests for information in less than 1% of all eligible cases. That is, I believe, the lowest level of merger scrutiny recorded since the FTC started tracking those statistics back in 1981. And just for comparison purposes, in 1981, that review was 5 times higher than it was in 2018. My question is, do you think that this record low level of merger scrutiny is appropriate? And if you're confirmed as Attorney General, what might you do to ensure that the Antitrust Division faithfully and vigorously enforces the law?
Well, I am for vigorous enforcement of the antitrust laws to preserve competition. And as I said, this is going to be an area I'm going to want to get into and work with Macon Delrahim on if I'm confirmed. I wouldn't necessarily use the incidence of merger review as a proxy for failure of competition. At the end of the day, it's competition we're worried about in different markets. But I am interested in exploring those statistics you were just using.
And do you think it's fair to say, would you agree that the historic levels of concentration that we're seeing in many parts of the economy, technology in particular, is potentially detrimental to competition? I mean, it is, again, potentially and in general, but it is something that is worth scrutinizing and being concerned about if one is concerned about free, fair, and open competition.
You said the size?
Yes, the historic levels of concentration.
Yeah, I think the thing I'm concerned about are the network effects that are now at work, where they're so powerful that particular sectors could essentially be subsumed into these networks. They're just very powerful network effects because of the size.
Yes. I see my time has almost expired. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Chairman, I welcome the arrival of the immigration Lindsey Graham of 2013. The other Lindsey Graham, we shall see, as you yourself have acknowledged. Mr. Barr, I ask these questions, these 2 questions of every nominee who comes before any of the committees on which I sit. And these are the questions. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
I have a question relating to recusal. You've been asked a number of times. It is very clear that the president does not want an attorney general who will recuse himself from the Mueller investigation. So when he came before us for confirmation in January 2017, Jeff Sessions wrote on his committee questionnaire that he would, quote, seek and follow the advice of the Department of Justice's designated agency ethics official if confronted with a conflict of interest, end quote. And in fact, he did do that, and he was basically pummeled by the president ever since. So Matthew Whitaker has not come before us for the job of general, but we know that when it came time to make a decision about recusal, he didn't want to be the object of Trump's wrath, so he proceeded to listen to and then ignore the advice of the career ethics officials at the DOJ who recommended recusal. So your answer to Senator Klobuchar's makes it clear that you are going to basically follow the Whitaker model. Can you understand why that is not terribly reassuring to us? These are not normal times. This is not 27 years ago. Today, the president is Donald Trump, who will do anything to protect himself. He wants you, who has written a manifesto about why the president shouldn't be prosecuted, at least for obstruction of justice, who has met with and consulted with the president's defense attorneys, who has written op-eds defending his firings of Sally Yates and James Comey to be his attorney general. So in this context, just asking us to trust you is not enough. Why won't you simply follow Jeff Sessions' lead and take and follow, the critical portion being follow, the advice of the department's ethics officials?
Because the regulations and the responsibilities of the Attorney General as the head of the agency vest that responsibility in the Attorney General. And I am not going to surrender the responsibilities of the Attorney General to get the title. I don't need the title. If you don't trust me
you have repeated that answer many, many times. However, I think we all acknowledge that Jeff Sessions possibly didn't want to recuse himself, but he did. And so you have it within your power to follow the ethics advice of your own department, and you're telling us you're not going to. So that is the bottom line.
No, Senator, I think Jeff Sessions recused himself because of a different provision, which was the political conflict provision.
I think
he played a role in
the
campaign.
In the context of all of the things that you have done, basically to get the attention of President Trump to nominate you, I would say that there's a political context to what your decision should be also. Let me move on. You have said that you will allow Mueller to complete his work. Although, I do want to ask you very specifically, because you did write that 19-page memo relating to the obstruction of justice issue. Would you allow the Mueller investigation with regard to obstruction of justice to also go forward unimpeded by you?
I don't know whether there's an investigation of obstruction of
Well, definitely obstruction of justice. You read the papers as well as we do, that is an element of the Mueller investigation. I don't think you can sit here and tell us that you do not think that that is a part of the investigation. But let's say that it is. Having written what you did, would you seek to stop that portion of the Mueller investigation? That being the obstruction of justice portion, assuming that that is in fact part of the investigation.
Okay, but you have to remember, my memo was on a very specific statute and a specific theory that I was concerned about. I have no basis for suspecting at this point that that is in play at all.
You mean that particular provision?
That provision or theory.
Well, I did say, let's assume that, in fact, obstruction of justice is part of the Mueller investigation.
When I say theory, I mean, what I was addressing was, whether the removal of Comey in and of itself would be obstruction.
Of course, it's not
under a particular statute.
I hate to be interrupted, but, I only have 4 minutes, so thank you very much. You were asked about the investigations that are going on in the Southern District of New York, the Eastern District of Virginia, the District of Columbia, and there are various investigations brought by various U.S. attorneys' offices relating to the activities of Donald Trump, his campaign, his inauguration, his foundation, his businesses, his families, his associates. Do you consider these to be lawful investigations? Because I believe that you responded to Senator Blumenthal that if these are lawful investigations by the U.S. Attorney's offices, that you do not see yourself interfering with them.
I have no reason to think they're not lawful investigations, whatever they are. You know, seem to know more than I do about what's under investigation.
That's reassuring that you're wanting to have the Mueller investigation go forward extends to all of these other U.S. Attorney's investigations. I believe you also said that the Mueller report will be confidential. It is confidential under the special counsel's, whatever the criteria are. So what I'm hearing you saying that in spite of the fact that you want to be transparent, neither Congress nor public will get the Mueller report because that's confidential. So what we will be getting is your report of the Mueller report, subject to applicable laws limiting disclosure. So is that what you're telling us?
I don't know what at the end of the day, what will be releasable. I don't know what Bob Mueller is writing.
Well, you said that the Mueller report is confidential pursuant to whatever the regulations are that applies to him. So I'm just trying to get as to what you're going to be transparent about.
As the rules stand now, people should be aware that the rules, I think, say that the independent, the special counsel will prepare a summary report on any prosecutive or declination decisions, and that shall be confidential and shall be treated as any other declination or prosecutive material within the department. In addition, the Attorney General is responsible for notifying and reporting certain information upon the conclusion of the investigation. Now, how these are going to fit together and what can be gotten out there, I have to wait, and I would have to wait. I'd want to talk to Rod Rosenstein and see what he has discussed with Mueller and what's, what.
But you have testified that you'd like to make as much of the original
Right, and so
report
all I can say right now
open as
is,
possible.
yeah, all I can say right now is my goal and intent is to get as much information out as I can,
Thank you.
consistent with the regulations.
So in the minute that I have, I'd just like to go over some of the policies that Jeff Sessions has followed. One is a zero tolerance policy, which led to the separation of children from their parents. He refused to defend the Affordable Care Act and argued in the Texas lawsuit that key parts of the ACA was unconstitutional. He failed to bring a single lawsuit to enforce the Voting Rights Act to stop voter suppression efforts. And he issued a memo making it harder for the Civil Rights Division to enter into consent decrees to address systemic police misconduct. Do you agree with these policies? Do you intend to continue them?
Well, the last one, yes, I agree with that policy. The other ones, I'm not, I'd have to see what the basis was for those decisions.
So do you think that as to the last one, which has to do with consent decrees, that there is a role for the Department of Justice in addressing systemic police misconduct?
No,
You don't see much of a role in that, or you
no,
see
that's
a
your
more limited role?
That's your characterization of it. That's not what I understand the policy to be. Of course, the department has a role on pattern and practice violations.
So the Attorney General Sessions has issued a rule that makes it a lot tougher to enter into these kinds of decrees.
Why do you say it's a lot tougher?
Because it's not just relying on the career attorneys, that now it goes to the deputy AG or whoever, that there are more political appointees who are going to get involved in that process, and that makes it much more limited, I would say, in utilization. Thank you, Mr. Chairman.
Your Honor, we'll take a 10-minute comfort break and start with Senator Tillis. My math is right. We've got about an hour left on round one, so 10 minutes be okay, Mr. Barr? Okay, thank you. Adjourn for 10 minutes.